Royal security is a logistical calculation of distance. While Windsor offers a fortified perimeter, the Sandringham estate in Norfolk presents a different reality: accessibility. In 2025, the Executive Committee for the Protection of Royalty and Public Figures, known as RAVEC, withdrew state-funded security for Prince Andrew. This was a strategic removal of the sovereign shield. The financial burden of protection shifted to the individual. For a prince without a portfolio, an annual security bill exceeding £3 million proved unsustainable. The consequences manifested on May 6th. He was reportedly wearing a balaclava, an image fundamentally at odds with the quietude of a royal estate. Police confirmed Jenkinson carried an offensive weapon. The perimeter had failed. Protection is no longer an inherent right of the bloodline. It is a resource allocated strictly to those fulfilling a constitutional role. When the duty ends, the fortress dissolves. How does an ancient institution survive when its members are no longer shielded by the state? The legal proceedings begin on July 29. Andrew will provide evidence via video link, a digital barrier replacing the physical cordon he previously commanded. The aristocratic leisure of a dog walk has been reclassified as a tactical liability. The trial scheduled for late July marks a definitive breach of the House of Windsor's judicial isolation. In the British constitutional framework, members of the sovereign's family rarely occupy the witness box. This distance is maintained not by law, but by an enduring convention between the Crown and the judiciary. The historical precedent for such an appearance dates back to 1891. During the Tranby Croft affair, the future King VII was compelled to testify in a libel case involving an illegal game of baccarat. Where the Victorian scandal concerns social etiquette, the current proceedings focus on criminal intent. Alex Jenkinson appeared before Westminster Magistrates Court to contest charges under Section 4 of the Public Order Act 1986. This statute specifically addresses conduct intended to provoke immediate, unlawful violence. The burden of proof rests on the prosecution to demonstrate that the defendant's presence at Wolverton was a calculated attempt to cause physical harm. Under this legislation, the court possesses the power of incarceration. This transforms a rural incident into a serious criminal indictment against a relative of the monarch. Existing bail conditions have already enforced a strategy of geographic exclusion. Jenkinson is legally prohibited from entering Norfolk or approaching the perimeter of any royal residence. The state is no longer acting as a guardian of royal dignity. It is managing a security liability through the mechanical application of the penal system. The law does not acknowledge the bloodline. It only measures the threat. On February 19, 2026, the traditional protocols of a 66th birthday were replaced by an 11-hour police detention. The charge: misconduct in public office. This was not a sudden maneuver by the Metropolitan Police. It was the technical result of a prearranged legal release following the death of Virginia Giuffre in April 2025. Her estate published an exhaustive memoir containing specific chronologies and logistics that investigators previously lacked. The manuscript provided the necessary framework for a renewed judicial inquiry. Simultaneously, the U.S. Department of Justice declassified a series of documents regarding the 2010 trade missions to Singapore and Vietnam. The evidence suggests a systematic overlap between state duty and private interests. The allegation is precise. It is claimed that official status as a UK trade envoy was leveraged to acquire commercial intelligence for the private benefit of Jeffrey Epstein. In the British constitutional framework, the exploitation of a public mandate for private gain is a fundamental violation. Misconduct in public office remains a common law offense that carries a maximum sentence of life imprisonment. The institutional shield has been withdrawn. The sovereign's relative now stands as a primary subject of criminal procedure. The July proceedings have expanded beyond the physical security breach at Wolverton. This is now an examination of the institutional contract between the individual and the state. When the bloodline ceases to be synonymous with service, The law recognizes only the citizen. The weight of royal history has been superseded by the weight of the penal code. Royal Lodge has transitioned from a private sanctuary to a structural liability. In the current reign, the 30-room Windsor residence is no longer viewed through the lens of family tradition, but as an underperforming asset. The 75-year lease, signed in 2003, was a rigid commercial contract. It included a specific legal covenant, the obligation to repair, renew, and uphold the historic fabric of the building. By late 2025, the reality of this commitment became unsustainable. Years of deferred maintenance resulted in extensive damp and masonry decay, with restoration costs far exceeding the tenant's private liquid assets. The king's mandate for a streamlined monarchy leaves no room for such deficits. The Crown Estate has moved to activate forfeiture clauses, reclaiming the property for the sovereign's portfolio. The future of the estate is purely functional. Royal Lodge is slated for conversion into a luxury event venue and public museum, adopting the commercial template established at Dumfries House. The consequences for the York lineage are absolute. By failing to meet the maintenance requirements of the lease, the prince has effectively forfeited a £30 million asset. Princesses Beatrice and Eugenie have been decoupled from the land. The sanctuary is now a storefront. The physical displacement from Windsor is merely a prelude. The British Parliament has moved from silent observation to direct legislative intervention. Succession to the Crown Bill of 2026 seeks to purge the 8th position in the line of succession. This is a calculated move for national security. A figure facing criminal inquiry is no longer a peripheral relative. He is a structural risk to the stability of the throne. The objective is clinical. The sovereign's seat must not be compromised by the proximity of a legal liability. Legislative momentum is driven by a 400-page dossier submitted by the pressure group Republic. This document provides a forensic inventory of alleged institutional shielding and procedural failures. In this judicial climate, political inaction is no longer a viable option. The institution is repeating its history, but without its former mercy. In 1936, the abdication of Edward VIII was mitigated by a substantial allowance and the curated dignity of a title in exile. The Duke of Windsor was a problem to be subsidized. The current reality offers no such grace. The king has recalculated all financial support to meet only the strict requirements of subsistence. There is no provision for the maintenance of a princely lifestyle or a global reputation. The crown is no longer sustaining a member of the family. It is managing the functional obsolescence of a former asset. This is the final stage of institutional decoupling. The man has been separated from the office from the land, and the bloodline from the protection of the law. The throne remains. The individual is erased. The witness box has been superseded by a digital terminal. This classification is a clinical admission of human fragility. In the British legal framework, such protections are a functional necessity, not a mark of status. The screen acts as a perimeter of containment rather than a shield of honor. The physical relocation to a Sandringham farmhouse confirms this contraction of influence. Wolverton is no longer a backdrop for aristocratic leisure. It is now the site of a documented security failure. By moving from the fortified isolation of Windsor to a Norfolk cottage, the prince has entered a space where the crown's protection is minimal. The law is no longer shielding a royal from embarrassment. It is documenting a credible threat to a citizen. The transition is absolute. The global trade envoy has been reduced to a local complainant in a digital box. The institution has successfully decoupled the safety of the throne from the safety of the individual. The crown remains intact. The man is on his own. Does the state's refusal to provide a royal shield represent a triumph of equal justice? Or has the sovereign effectively abandoned his own blood to the court of public opinion? State your position in the comments below and subscribe for our continued forensic analysis of the House of Windsor.